Member Viewfort Library, can you turn on the off? Member for Library. Member for Viewfort South.
Mr. Speaker, my comments will be brief after the very incisive analysis of the bill by the member for Castries South. However, Mr. Speaker, I want to preface these comments by a general observation regarding the treatment of legislation. Mr. Speaker, there is a creeping tendency in this House that when members speak to the content of legislation, issues with legislation, that somehow an impression is being conveyed that they have some agenda against the Attorney General's department or the drafting personnel in the Attorney General's department. Of course, there's a particular way the member for Castries Southeast puts it. He says, well, they're the same people who drafted 4 members when they were in government, and now we are finding problems with them. Mr. Speaker, I really do think that the House should make a judgment of when sincere objections are being raised about legislation before the House. And if the opposition is making a contribution by identifying weaknesses and problems with the legislation, it is not that in the vast majority of cases, members of the opposition want the government to withdraw their bill, only that the bill be cleaned up, perfected, tidied up. Because at the end of the day, when it reaches our statute books, the House as a whole is held responsible for the legislation. I have been the subject of all kinds of commentary when I make suggestions regarding legislation. I even recall, Mr. Speaker, on the occasion that we were debating the Castries constituency bill, a bill which reeked with problems, and we will begin to discover the full extent of the problems as the bill is implemented, and already we are seeing signs of what's going to happen. But I recall that there was a provision in that bill which spoke of common law powers of police officers. And you're a former magistrate. I pointed out that we have always had a criminal code from 1914, 1916. And there's no such thing as common law powers of police officers. And persons found that objectionable to point out that this is wrong. You can't put something like that in legislation. And what has happened? It has reached our statute books. And so a country like ours that is a codal jurisdiction with a criminal code, we have the extraordinary provision that speaks of common law powers of police officers. That's the kind of issues that we have. When very simply, we could have corrected the legislation in its passage, particularly at the committee stage. Some bills, Mr. Speaker, can be rescued. Some bills need sometimes to be withdrawn and rethought. And really the test of doing that is simple. Is the bill so flawed that on reaching committee stage, it cannot be remedied by a series of amendments to the bill? I think what members on this side are trying to say to the government, this bill is too flawed. You can keep your concept, your idea, which of course I shall come to in a few minutes, but that it requires some revision. but we treat it as a one-upmanship, that if the government says, all right, I'm going to rethink, then it's a victory for the opposition, and Lord forbid, it's a victory for Kenny Anthony in particular. But I'm not the lead spokesman on the bill. The member for Castries South is. But that's a tragedy of this. It's unnecessary. Now, Mr. Speaker, that having been said, I want to focus on a few points pertaining to this bill. Much ado has been made about the fact that in Section 33 of the existing legislation, the section dealing with the establishment of the St. Lucia National Economic Fund was very brief. In fact, it was scoffed at, it was laughed at, etc. And the member for Castries South East is fond of reminding us that when he sat on the opposition benches, he sometimes drew attention to legislation, was told, well, we can go ahead and pass such legislation and adjustments will be made. And I think the merit of the advice, even in his own thinking, has value, because today in this House we have a classic example, the Adoption Act. Passed just a few weeks ago, we now have to come back to this House and introduce a series of amendments. Now, what are you going to do? Go and blame the Attorney General's office or blame the minister? These things happen. They're inevitable. And I am going to go even further and say that that legislation we pass, even though you're amending it in this sitting of the House, you're going to come back again in the weeks ahead and make further amendments to it because of its imperfections. And what? We on this side should gloat about that? It's a normal incident of the passage of legislation. Now, yes, Mr. Speaker, Section 33 was brief. But, Mr. Speaker, that is not justification for introducing this bill. That can never be the justification for it. What the government has objected to and opposed is the fact that projects had to be brought to the House to be debated. The Minister of Finance was required to present proposals to the House, and it is the House that had to decide whether these proposals will proceed to funding. You know, Mr. Speaker, life has some curious ironies. Sometimes it's impossible to understand things with the clarity they need to be understood. But those of us who are privy to the creation of the legislation, the drafting of the legislation, who saw the legislation in formation, who understand the background of the legislation, sometimes could give good testimony. Why did we adopt this approach that the House must approve the expenditure? In actual fact, it was meant to reflect the very openness and transparency that is being championed. Because even though this legislation may have had imperfections, the then government was very clear that no matter how difficult and hard it was, we needed to create some kind of partnership with the opposition on the CIP. Because in its creation, we ensured that the opposition was represented on the committee that led to the decision to accept the CIP. And I have never, ever denied the fact that I have said that I have profound anxieties, and for me, it was a journey to accept the CIP. But that is a matter that I would deal with in my own way at the appropriate time. And when the government enacted Section 33, and what is surprising is this, everybody believes that that is the only section that speaks to the St. Lucia National Economic Fund. We made it very clear that we had to put flesh on the bones of the legislation, and for that reason, we created a section 40 with elaborate powers to enact regulations. You could have corrected whatever defects you think you had by simply enacting legislations because you were empowered to do so. But look at what section 40 subsection B says. Without prejudice to the generality of subsection 1, the minister may make regulations in respect of the requirements for a St. Lucia National Economic Fund investment.
He said so over and over that there were no regulations.
No mention is made of this, Mr. Speaker, in this debate today. Everybody's making fun about 5 or 6 lines in section 33. But the intention was clear,
He said so.
very, very clear. And the former government, in its wisdom, recognized that the process of implementing the CIP would have taken time. And therefore, what you needed to do was to create enabling powers. So this could have been done by regulation. And if that is the case, then you understand the depth of the problem in coming with a different kind of legislation, conceptually different. The intention was to get away from Parliament, from a debate on Parliament. The opposition is too troublesome, especially over CIP. That was never necessary because you had the empowering means to do so. Mr. Speaker, there are really some other troubling aspects of this bill, and I'm going to touch a couple of them very briefly. Let's go back, Mr. Speaker, to clause 4, functions of the fund. Mr. Speaker, I'm going to come back on this matter of the government of St. Lucia becoming a loan agency. Come back to that. But I want to focus very briefly on clause 4(1)(e). It says the functions of the fund are, and look at E, to provide monies for a purpose approved by cabinet that is not considered recurrent in nature. Now, what is this animal? What is this animal, this project that is not recurrent in nature, but it is not a capital project? What is it really? What amorphous animal is this? What amorphous entity is this? But there's a greater problem, Mr. Speaker, and I know you have heard this before from me ad nauseum. Doesn't matter. These things will eventually get contested in different fora. The concept of to provide monies for a purpose approved by cabinet, you proceed to establish in clause 4(1)(a), B, C, and D purposes to be financed, to advance loans to the government, to provide investment for a government-approved capital project, to reduce government debt, to purchase government bonds. And you're not satisfied that you have covered everything, then you introduce an E to provide monies for a purpose approved by cabinet. Why bother with the other subsections? Why bother with the other subsections? And you would know, Mr. Speaker, that uncertainty is fatal to law. That is why we keep on raising it with members of the government to give more specificity to what it is that they really have in mind. How can you then blame us and make us feel that we are causing so much injury to you, causing you so much harm, causing you to make you feel that we believe that we are the only ones who know what to do and how to do it? That's not the point. We are simply making these suggestions to persuade you to make the adjustments to improve your legislation. Now, Mr. Speaker, if you just bear with me again. Look at this. Let's go back to one that has been talked about. Look at Clause 6, Mr. Speaker. The board consists of not less than 5 members and no more than 7 members to be appointed by the cabinet as follows. I have heard the explanation offered by the member from Castries Southeast, and I know, to use language that you'll understand, the member for Castries Southeast is the de facto legal representative of the government of St. Lucia in the House. I mean, he is the authority on legal matters. Yes, he's got a promotion, I tell you, because if you notice that he goes through the corridors to discuss with the AG the legislation, what changes must be made, how he's going to reason, how he must say what, etc., etc. And of course, you know, Mr. Speaker, what he has said in relation to the opposition and myself personally about our legal trading, but leave that for the time being. So he has given an interpretation of what this means. If the member for Castries Southeast is correct, why on earth didn't the drafting department say exactly what he said? Why enact legislation with such ambiguity? But what baffles me, when you then go to Clause 11, remuneration, Cabinet shall, on the recommendation of the minister, determine the remuneration to be paid to the members of the board. Of the 7 members, 6 are civil servants. Why is remuneration being paid to civil servants who might be performing those functions in the course of their normal duties? Why are we creating that kind of precedent? Why we have added on to their duties by putting them on these boards, and then on top of that, when they are meeting to make decisions about a business or government, you're going to pay them? There's only one private sector person on that board. Not that I know of. Certainly, when we are in office, we discourage it. Should not happen. Should not happen. Should not happen. Not when they're performing their duties in a normal course of their employment. Well, customs is a different issue. Different issue. You're dealing with practice conventions where they are concerned. But this is madness. Now, Mr. Speaker, my deepest concern is a conceptual one. We are transforming the government of St. Lucia into a lending agency.
I think it's in performing the same duties.
The government of St. Lucia has now become a loan agency. Because when, Mr. Speaker, you look at Clause 6.4, the board shall manage the monies and business of the fund, consider and approve an application for a loan or an investment in a government-approved capital project, ensure that a loan is used for the purpose for which it was granted, ensure the repayment of a loan at the time it is due, ensure that the proceeds of the loan are applied to the government-approved capital project, establish and maintain, the favorite one of the member for Castries Southeast, establish and maintain a sinking fund. Now, Mr. Speaker, why would the government in this day and age become or transform itself into a lender? Make decisions about granting loans to developers. You know, Mr. Speaker, this one baffles me. Why would the government put itself into a position where itself or the persons employed by it can become under serious pressure, duress over applications for loans? And Mr. Speaker, the opposition is raising a serious issue, albeit the member for Castries South East. If you look at clauses 12, subclause 4, and clause 13, subclause 4, the word credentials is used. So you can refuse a loan if you're not satisfied about credentials. Now, Mr. Speaker, for goodness sake, you're a lawyer, well, you've been in private practice, you've been a magistrate. What on earth does credentials mean? Does it mean financial competence alone? Does it mean moral probity? Does it mean support? Well, it could also mean political affiliation. That is why you cannot leave a term like that at large. All that you needed to do was to define the term credentials in clause 2 and say that by credentials it is meant financial ability to invest, financial probity, blah, 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 and make it clear. As you have drafted, it leaves it at large. That is what the member for Castries South was trying to say, you know. That this is loose, it's going to put you in trouble. Clean it up. But Mr. Speaker, I think it's sad that we have stripped Parliament of some measure of partnership and accountability. You have seemed to have a passion for parliamentary reform. And you know, one of the worst provisions, I think, most abused provisions in our legislation is contained in clause 19. The cabinet and the government has decided that Parliament will not be involved in making decisions about how we're going to deploy CIP money. Rather, what is going to happen is a report will be laid. Every single person in this house knows that that is the easy way out. Because, unfortunately, we have never ever developed a mechanism to examine, to consider, to debate reports that are laid in Parliament. We made a very timid start with the last government when we had a parastatal unit, and reports, statements of accounts were sent to that unit for evaluation, and the intention was eventually to amend our rules to allow opportunities to debate whatever is laid in Parliament, particularly the accounts of statutory bodies. So we all know full well that once you see a report is going to be laid, that's it, matter closed. Of course, Mr. Speaker, you're welcome to make reference to it in debates, in speeches, in commentary, because it's now part of the official record of the House, part of Hansard. But the nitty-gritty of going in to discuss and debate the fundamentals, we don't do. And that is rather unfortunate. So, Mr. Speaker, I join my colleagues. I can't support this bill. It doesn't matter, I guess, at the end of the day. But this is defective legislation. And the government can do a better job at achieving their objectives in this legislation if they sit back, listen to these comments, and then make adjustments before we proceed to the third stage. Thank you, Mr. Speaker.